The law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to help yourself, your family, and your business when that applies. We continue to provide information and resources that will help you to determine whether or not you want to contact a lawyer. Perhaps the information will help you to decide that you can actually handle some issues yourself. If you do decide to seek professional counsel, you'll be better prepared, and as a result, so will the professional you select. Our goal, of course, is to help you to save time, money, and achieve the best possible results. We welcome and thank once again our attorney, David Bazar, from the Bazar & Associates law firm in East Providence, who continues to weigh in on the various topics that we tackle each session. And today, our topic is mediation. This, along with arbitration and a couple of others, are what's referred to as the alternative dispute resolution. David is both an attorney but also a mediator. There's a distinction, and we'll review that. So litigation, of course, can be time-consuming, expensive, a headache. It's unpredictable. There are a lot of reasons that if people can avoid it, they want to. So, David, go through a little tutorial, if you will, about arbitration and mediation, and why mediation is becoming so popular today.
Okay. So as you said, mediation, arbitration are forms of alternative dispute resolution, meaning that most cases are resolved if they're not done by settlement negotiations or whatever, and they go into suit, it goes through the court system. And these are alternatives to a jury trial in many cases, or just a trial by a judge. In any event, these alternatives present different ways of resolving a case. Mediation, which we'll talk about in some detail, involves really a mediator going between the two parties to bring them to a resolution that they actually have some control over, as opposed to an arbitration, which is maybe a mini trial in many ways, without a jury, heard in front of one arbitrator or a panel of arbitrators, and that can either be binding or non-binding, and it's a decision made by someone else after hearing the facts of your case. I
think there's quite a bit that you've mentioned there. We should do a drill down, but it's important to note, I guess, that whether it's mediation, when we're dealing with mediation, that's something that can be done in divorces as well as business issues, and even things that need to be resolved before they would even consider being part of a pre-law litigation case.
Right. So mediation can be used in a wide variety of settings, and you mentioned divorce as one, and in fact I think mediation is actually very well designed to resolve disputes in a divorce situation, because court is a very aggressive form of litigation that can be divisive amongst the parties. And it's already enough animosity going into a divorce situation to heighten that with litigation. What mediation does, it makes people sit down, and mediation done well makes people listen to each other. And oftentimes, that's the first time these two parties have sat and talked about resolving issues amongst themselves. And by getting them to listen to each other, it not only helps resolve the case, but may help their communication going on down the road after a divorce is heard.
So, sticking with that for a moment, David, if, in the case of divorce, people are already in an unhappy place, perhaps a contentious place, how they automatically think about going to a lawyer, how would they, once they go to a lawyer, how would that ever, that's where they would think to go first, how would they ever think to go back to having a civil conversation with open discussions, such as you're talking about, unless they knew about mediation in advance, that is?
Well, many times you come to an attorney about your situation, and the lawyer will advise you on your rights, and may perhaps say, one of the things you might think about is mediation. And mediation can happen before a divorce is filed. The parties can go to a mediator and have everything resolved so that when they go to court, it's really just a matter of presenting to a judge the terms of your divorce and having the judge approve those. And while you need to go to court to get divorced, you can either go to court with the case already resolved through mediation, or you can file. And you can start with an acrimonious type of situation, which at that point in time, the judge may say, you folks need to go to mediation first. So you can end up in mediation in a divorce setting in a multiple or variety of different ways. But the idea is that sitting down and resolving those issues amongst yourselves first, or at least taking the chance at it, rather than leaving it to a judge who's going to listen to the facts for the first time when each of you testify in front of the judge and doesn't know your case as well as each of you do. You're leaving it in that third party's hands to decide what it is that's going to happen, and both of you may not be happy with whatever that result is.
I know we've often talked about whether something goes to a court judge or to a jury. It's often, the outcome's often unpredictable, and you're saying when you go into mediation, there ends up being, I guess, theoretically a contract that everyone has agreed to, or the parties have agreed to, and go from there. But help us understand who the ideal candidate is for mediation. I mean, if someone maintains that they are hardwired to have a fight, I imagine that's not the best candidate for mediation, unless someone can talk them off a ledge. How do you do that, David?
Well, as a good mediator, you can deal with anybody. The only issues that we sometimes need to ferret out for mediation to be successful is, do the two people have equal bargaining power, so to speak? We can't have overreaching. You can't have one party who really is dictating terms of the mediation and the other party doesn't have that equal footing, and the mediator has to make sure that they do. So you look at different things. In a family court setting, if there's been domestic abuse and that type of thing, it might not be a case that really can be successfully mediated because there's probably some control or power of one party over the other. So for mediation to work, one thing you need, first and foremost, is equal footing for both parties to be able to stand up for themselves and be able to advocate for themselves. And so that's one. Although oftentimes, and I'm talking mostly family court there, because oftentimes in mediation, you can have attorneys involved in the mediation, so therefore you assume that you have equal footing. Another thing you need for mediation to be successful is a complete, and again, mostly family court here, disclosure of all of the assets and liabilities of the parties, so we know we're dealing with the complete case and everything that needs to be dealt with. You can't have concealed assets, and you can't have one party trying to say, yeah, I don't have a pension, when in fact I do. You need to have complete disclosure of all the assets. So equal footing, complete disclosure of all of the issues and assets, and then an ability for the mediator to get the parties to sit down and listen to each other.
So would there be one mediator between the two people, even if both or one has already enlisted a lawyer?
Yes. So
how would that work?
Again, family court, usually it's just the parties who are at the mediation with the mediator. But as a mediator, I tell them there are experts that you may need to consult with as this process is unfolding. So you have a session, and at the end of the mediation session, you might say, okay, here are some things you need to go and look into before we come back for the next session. There might be a disagreement as to what the value of real estate is. You might want to talk to a real estate expert, a broker, or appraiser, or somebody, so that either the parties can agree to what the value is, or they each can come in with their own experts so that they've consulted with that. There may be some tax issues, so I would say you might want to talk to an accountant or some other tax advisor as to what the issues are on these tax issues. And even though I'm an attorney, if there are legal issues, I'll tell them, you each should go talk to your own attorney and find out what the legal ramifications are of what you're suggesting, so that you've each had your own independent counsel. Because as a mediator, as you said, even though I'm a lawyer, I'm not serving in that role, and I'm not there to give legal advice to either party. I'm there to suggest to them what possible resolutions are and help them determine amongst themselves what resolution they want to reach is.
So when you are approached initially as the lawyer, because that's what most people would see on your door, might you then have to explain to them the distinct differences between the role of the mediator and the role of the attorney, including the fee structure. I understand that mediation is less expensive regardless of what the per hour cost. I understand that could range from $200 to $500 an hour, but that's not to say that attorneys aren't retained for many more zeros once they are in a forensic issue and heated debates and all the rest of that. But how do you bridge the gap or make a transition or the distinction when someone comes to see you?
So when somebody comes in to see me, as a mediator, they've usually been referred to me to be a mediator.
By a lawyer?
Another lawyer.
Okay.
Other clients that have gone through mediation, finding us online, however it is that they've been referred, they're usually sent for mediation if they come to see me as a mediator. If someone comes to see me as a lawyer, then I won't take the case for mediation if they've hired me to be a lawyer, because that would be a conflict. I couldn't do that. But if they came to me before we've discussed anything about the case and they say they're either interested in mediation or they want to know more about divorce, before we even start, I say, don't talk to me about your facts or your divorce. If you are interested in mediation, we can do this as mediation, but you and your spouse have to come in together. And so I would cut them off right away before I would even speak to them about their case or anything if mediation is an issue.
Important distinction. So we say that that mediation is supposed to be a little more amicable under the circumstances, and when people want to avoid some of the emotional distress and hassle, speak to that, how that benefits or in what ways it can benefit the couple if there are children involved.
So what happens in divorce at trial level is you have to bring out all of the negative facts that you want against the other side and the positive facts on your side in order to get the judge to do what you want the judge to do in determining how your case should be decided. In mediation, you don't have to raise all of those issues. So right out of the gate, it's less of a divisive situation and it's more amicable. And so what you can do is, and how a mediation works is I meet with the parties first and we go through what the issues are and what types of situation, every case is different. So what is it in your case? Are we dealing with children and those types of situations primarily? Because you have to deal with everything. It's distribution of assets, it's whether or not it's an alimony case, it's how you're paying your debts, and it's the issues surrounding the children, child support, and all of those things. So once we map out what the issues are, I will meet individually with each of the parties. You might call that a caucus or shuttle diplomacy, if you will. And at that point in time, things can be shared with me that are confidential and don't necessarily need to be repeated to the other side. And it might be things that would be hurtful to the other side, but they're said in a confidential setting so that I can help determine what needs to go back to the other side to try to move them on their position, or what doesn't, so that even though things are being shared with me that might be hurtful, they don't necessarily have to raise the level of discourse between the parties to a point where you're becoming divisive.
So we're speaking of divorce, but it sounds too that you could easily make that transition to, what about in a business? Two partners are going to divorce, separate their assets. Just as in a divorce as we know it today, when people are entering business, they never think that they're going to dissolve a partnership that was made in heaven, such as you would expect and don't want it to be. But might someone come to you to just resolve those minor issues or major issues about how you divide things up if they're ultimately going to separate?
Just like mediation is a very good vehicle for divorce, it's an excellent vehicle for dividing up assets either in a business setting where partners are dissolving the business, or even in probate where there's a dispute in an estate. I've done a lot of probate mediation where there's a dispute as to who should be the guardian and why, or how assets in an estate are being distributed, and there's a dispute as to whether or not a will should even be admitted to probate and one's challenging or not. There's a lot of different settings where mediation can be extremely beneficial to the parties to resolving it rather than doing it through litigation.
How does one become a mediator? I mean, I imagine that all lawyers could be mediators, not necessarily all mediators are lawyers, but
That's correct.
Where does that work?
So
how does it happen?
To be a lawyer, there's a whole process you have to go through. To be a mediator, it's very different. And there's a training session you can go through that I did. Roger Williams law school has a mediation program, but they also have, they had, at least at the time I did it, a training session for people to be mediators. And it was really helpful training. You don't have to do that, actually. You can say you're a mediator and want to be mediated, but to be qualified in different areas by folks that will let you mediate through, for example, we had a list of mediators that had to be approved by the chief judge of family court in Rhode Island. You had to have some certification and so forth that the judge approved and accepted for you to be certified on their list of mediators. The court has actually since put through a program in the courthouse itself where there's available free mediation. And those are cases that either come through the court system where it's required. For example, in Rhode Island, miscellaneous petitions have to go to mediation before they can be heard by the judge by administrative order, or are referred by a judge out of a divorce or something else that's in front of the judge that they feel mediation would be helpful for.
And at what point is there, or how do they discern between what's being mediated, what will go to arbitration, and please explain non-binding and binding arbitration,
Okay.
who takes advantage of which?
So mediation is the process that the family court in Rhode Island primarily uses as alternative dispute resolution. In Superior Court, for example, there's what's called in Rhode Island court-annexed arbitration. And every case, with a few exceptions, have to go through the court-annexed arbitration process. And in Rhode Island, in Superior Court, that process is a non-binding arbitration. So you pay your fee to the court to get into the arbitration system, and then after the arbitration decision is made, either party can appeal by paying a fee and saying we reject the arbitrator's award, or if both sides accept it, then there's a fee that's paid in accepting the award, the plaintiff decision or defendant's decision. Binding arbitration is an agreement usually between the parties, so there's an arbitration agreement usually signed as a contract saying this is what we agree to do, and we're submitting all the issues in this case to arbitration, and whatever the decision of the arbitrator whatever decision is made is binding and enforceable through either having the court confirm the arbitrator's award or otherwise. So once you agree to go that route, you're bound by whatever the arbitrator's decision is. There's a few very specific reasons why an arbitrator's award might be set aside, but it's very rare.
So if you decide to, if arbitration is one of the options, that is still an adversarial situation. Is that how would you help our viewers determine whether or not they can represent themselves during that kind of a process versus lawyer up, you need someone to present your case?
So arbitration is used in a number of different settings. And it's interesting, most of those settings you want an attorney representing you in. There are some that go back, and there's even been some case law and some decisions in Rhode Island on as to whether or not a lawyer needs to represent you in certain different settings and whether it's the unauthorized practice of law or not. For example, in a lot of union disputes, there are arbitrations that are mandatory. And I don't believe that it's always a lawyer representing each of the parties to those settings. Usually the union is represented by a lawyer, but sometimes the union member is not. I would, if I were the member, want to have a lawyer if I could. I'm not 100% familiar. I don't do those types of arbitrations, but I understand that there's some case law that says that based on practice and the history of how these have done, it's not always required that the person representing you be an attorney.
So under what circumstances might you be less than happy with who that arbitration panel, who's sitting on that arbitration panel?
Again, it depends on the setting of how the arbitration came up. There are certain arbitrations where you get to decide who the members of the panel are by this process. Three-panel uninsured motorist arbitration in Rhode Island. The plaintiff gets to pick one member of the panel. The defendant gets to pick the other member of the panel, and they usually pick the third member of the panel, the neutral party, if you will.
And I guess the question not to be political, but in some circumstances, there's a question about who else is serving on, who that third person might be, and whether or not they have a perceived, perhaps imperceptible, a perceived conflict of interest, in which case maybe you can contest that, or arbitration means it's done, right?
Usually that you can't contest it after the fact because you've agreed to it. So usually it's in that setting that I described, you're agreeing in advance, so you know all of the issues with the neutral party before you agree to that party.
When consumers sign on or sign a contract with a company, a large company, there's a clause somewhere down in the 4-point mouse type of what has to happen, arbitration. Right. Can you address that topic and how you deal with it?
And there's some question as to whether that's a contract of adhesion because it's such small print and you can't see it, and is it enforceable, and should it be enforceable? Sometimes it is enforceable and you have to go through the mandatory arbitration. Sometimes, depending on the facts and the setting and the situation, it's not enforceable. And then sometimes there are issues that are required for the arbitration and other issues that are in dispute that are not required. And so if it's in a court setting, the court has to determine whether or not it should hear the whole case, part of the case, or none of the case. And so it's a fact-driven decision, and so you have to look at the facts of all of the circumstances, including what's in dispute, what's covered by that arbitration clause, and is the arbitration clause in and of itself enforceable or not enforceable.
For as much as there is in support of using mediation, arbitration, there are also counter arguments about why it doesn't work or why it isn't productive. Apart from taking a large caseload off the court's backs because they're backlogged as it is, how would you argue the other side of the case, that arbitration, mediation, they aren't always used, certainly, and they're not used as extensively as they could or should be? Or what do you see the downsides?
So tell me which side you want me to take.
Take the downside of why you should not be using arbitration and just go right to a court.
Yeah, well, there are certain cases that mediation's not going to work on because the parties are too entrenched in their position, and that's never going to change. And as good a mediator as you might have, me, just kidding.
It's off the table.
Not really. But as good a mediator as you might have, they're not going to be able to bring the people even close because they're so far apart. So in that type of situation, mediation's just not going to serve a purpose. In arbitration, the advantage of arbitration, if it's not binding, is sometimes you get to hear what a third party thinks about your case, and that may bring you closer even if it doesn't resolve it. But again, sometimes a case is just too expensive to arbitrate because of all the things that would have to get into it to do it right. So you're sort of trying it twice. And even the Superior Court rules recognize there are some cases that if the value of the case is more than $100,000, for example, you can opt out of arbitration because it's going to be very expensive to get that case in a position to arbitrate. And for the cost of arbitrating it, if it's taken seriously, you're trying the case twice. So why do it?
Okay. A purely subjective question, David. What's harder to get resolution to? Something that's emotional or something that's just and only financial? So, for example, what do we do with the dog? We're getting divorced, versus I'm not sure that I want my ex to have half of my pension. Is there one more than the other that's harder to resolve?
An emotional issue is harder to resolve because it's an emotional issue. Dollars and cents are dollars and cents. And sometimes the difference between all or nothing is something in the middle. Sometimes the difference between an emotional issue is much harder to get to.
Okay, and back to the business issue of resolving cases. In recent shows, we've talked about Monsanto, Bayer, and Roundup, and the very litigious issue that's going on, including class action suits. We're talking with millions, perhaps even billions of dollars, and the cases are being appealed. What's your thought about the fact that in at least the state of California, they're looking to mediate this now after all of that litigation, which has gone on. Never mind how much more lies ahead that we can't foresee. That could possibly be mediated after all of this contentious issue.
It's a good case for mediation because it's dollars and cents, and the company can look at it and they can say, we're not responsible for this, we had nothing to do with this, we can defend this in court all day long, but this is how much it's going to cost us to defend it and defend all of these cases. And so from a business perspective, this is what we're willing to do. And the plaintiff can look at it and say, well, we might have won this one, we might lose these other ones. To try all of these is very expensive. And maybe from a business perspective, we can make a decision where we're able to obtain money in a settlement of all the claims and resolve it that way. So it's dollars and cents. So those are business decisions that a mediator might be able to really get the parties to come to a number.
That's very fascinating. I guess also from a public relations standpoint, something about which I'm somewhat familiar after a few years doing it. If something is being mediated, that contract and that discussion can remain private and confidential, can it not? As
Correct.
Opposed to when something is going through the court system, it's published on the front or back page or every online site from now until the day it gets resolved and then appealed and all over again, correct?
Settlement negotiations are confidential. So you can require that anything said in a mediation be kept confidential. And one of the agreements that a mediator usually will have the parties sign is that the mediator cannot be subpoenaed to court to testify to anything that went on in mediation. And parties need to know up front that a mediator is not a witness, so a mediator can't be brought to court for anything.
Those are good, finer points, but very good points. Also, timeshare is often a legal issue for those who want to get rid of theirs. Now, in view of Brexit, which is unresolved, UK, EU, it's very interesting, but in the courts now they're talking about having that timeshare situation resolved and what litigation will come of it because of the unresolved situation between EU and the UK. Can you imagine that could be mediated now when there are such issues about jurisdiction and land and property rights, because that's what the Brexit's about? Can you imagine that something as contentious as that and as with those legal issues that could be mediated also?
Not only contentious, but very complicated. But the point is, you can really mediate anything as long as you understand the complexities of all the issues are on the table, and the parties have equal bargaining position.
It's interesting. So from the smaller or relatively inexpensive issues about divorce up to multi-million-dollar cases, mediation can work.
Yeah.
So thank you for addressing these issues. We hope that if you have such issues, alternative dispute resolution may be something that you can consider. And we hope that you will continue to stay tuned into Law Matters because, as we say, the law matters to you.